First up, though, is the big news about Hillary Clinton and the federal court ruling this week that she has to answer more questions on her email practices. Now, Judicial Watch has taken the lead in uncovering the Clinton email scandal. In fact, it was our litigation, our Freedom of Information Act litigation, that led to the disclosure that Hillary Clinton had this email system that she was using to hide emails from you, the American people, and from Congress and from investigators. And as a result of that misconduct, the Freedom of Information Act that Judicial Watch uses to investigate her State Department and other agencies was thwarted. And the courts were misled, it looks like, by the State Department in suggesting they had looked everywhere they needed to look in terms of responding to our FOIA requests. They never told us about these Clinton emails that they weren't looking at, and courts were upset at that. And one of those courts, Judge Emmett Sullivan, who is a U.S. District Court judge, a federal judge here in the District of Columbia, granted Judicial Watch discovery in one of its affected Freedom of Information Act cases. We deposed Cheryl Mills, top aide to Hillary Clinton. We deposed Yuma Abedin, another top aide to Hillary Clinton, who also had a secret email account on the system that was used for government government business, and other top State Department officials from the Clinton-era State Department. And that was discovery that Judicial Watch took. The FBI did their sham investigation. We did a real investigation. In fact, the FBI, incredibly, was using Judicial Watch Freedom of Information Act documents to question witnesses in its alleged investigation of Hillary Clinton's email practices. So one of the things we were allowed to do by Judge Sullivan was to ask Hillary Clinton written questions under oath, meaning they're called interrogatories, so that she needed to respond to them under oath. And I think there were 24, 25 questions. And she said, I do not recall, many, many times in response to our questions. But there are 3 questions that she refused to answer, objecting to them and refusing to answer. So we had to go back to the court with what is called a motion to compel her answers to these questions. We had other issues as well, because the video of the depositions of these aides, as I said, were taken by Judicial Watch attorneys. Now there's a court reporter there that transcribes them, so there's a written record, but there was also a video reporter there, so there's a video of those depositions. And I was able, as president of Judicial Watch, to attend, I think, almost all of them. But the video isn't available because the deponents, Cheryl Mills notably and Yuma Abedin, came in and said they shouldn't be released publicly. And the court initially sealed these video depositions back in 2016. And so that was an issue, because we went back and said, look, the election's over. There's really no good reason to have these videos secret. And on top of that, there was a State Department employee, John Bentel, who was a top IT guy for the Secretary's office. And we wanted to question him. Well, he took the Fifth Amendment in our deposition, so we sought to compel answers. We thought he couldn't credibly take advantage of the Fifth Amendment protections not to answer our questions because there was no credible fear of prosecution. So all of that was pending before Judge Sullivan. So we had finally a big hearing on it this past week, and I attended as president of Judicial Watch. I'm the client. I was representing the corporation, and Michael Bekesha, who you may have seen on other Judicial Watch reports here on video, was our attorney in the courtroom representing Judicial Watch. Now, on the other side were 8 attorneys for the other parties. You had 2 Justice Department attorneys. You had David Kendall and an associate representing Hillary Clinton. I think you had 2 attorneys representing Mr. Bentel. You had an attorney representing Yuma Abedin, attorney representing Cheryl Mills. So a lot of lawyers arrayed against little old Judicial Watch in this court hearing. So the court heard argument for about an hour and a half on all these issues. And he ultimately ruled that the video depositions could not be released because he thought that they could cause embarrassment and harm to the deponents. We just didn't buy that, but the court ruled as he did. He also ruled, interestingly, that Mr. Bentel didn't have to testify because the Fifth Amendment concerns he had were credible, in the sense that there was a credible fear of prosecution, because the court looked at the record. This is something that's worth noting, and found that Mr. Bentel may have lied to Congress. And the prosecution for lying to Congress, perjury, could possibly still take place, because the statute of limitations is 5 years. So I think the deposition, the testimony took place in 2016, and I don't think the statute of limitations would run to 2021. So don't let anyone tell you that the statute of limitations, at least as it relates to perjury, has run on the Clinton email scandal. So the long and short of that is we can't get to question him any further on these issues. But the big news is we were successful on this key issue, which is getting Hillary Clinton to have to answer questions she otherwise objected to. And 2 of the questions we won on, a third we didn't win on. I don't need to get into the details as to why we didn't win on the third one. I disagree with the judge there. But on the 2 we won on, they include information about why, and I'll read the question specifically to you because it's worth reading. Because these are not unimportant questions. These questions go to the heart of the Clinton email scheme. Mrs. Clinton, over her objections and the objections of the Justice Department and the State Department. Yes, we were in court this week fighting not only Hillary Clinton, but the Justice Department lawyers representing the State Department, who were on her side on this very issue I'm talking about, not only on the secrecy of the videos. They were on the side of Yuma Abedin and Cheryl Mills and State Department officials who they didn't want more information out about how they conducted themselves with the Hillary Clinton scheme. But also they were trying to protect Hillary Clinton from having to answer some of these questions, and specifically this question. Describe the creation of the ClintonEmail.com system, including who decided to create the system, the date it was decided to create the system, why it was created, who set it up, and when it became operational. So a lot of questions all up in that one interrogatory, and an important question that the American people deserve a straight answer to. And now Mrs. Clinton has 30 days to respond in writing under oath to this question. The second question is, during your October 22nd, 2015 appearance before the U.S. House of Representatives Select Committee on Benghazi, you testified that 90 to 95% of your emails were in the state system, and if they wanted to see them, they would certainly have been able to do so. Identify the basis for this statement, including all facts which you've relied on in support of the statement, how and when you became aware of these facts, and if you were made aware of these facts by or through another person, identify the person who made you aware of these facts. She didn't want to answer this question. There was an attorney-client privilege assertion, and the judge found that was not sufficient. She needed to answer the question, and if she could provide information outside the scope of any attorney-client privilege, she needed to. Now, what's important about that is Mrs. Clinton had put forward, I think, the misleading information that the State Department had all of her emails. Even though she took them all, any that were missing or needed to be found were there in her system. Well, we had a deponent, someone testified from the State Department, who said that was misleading because it would have been nearly impossible to gather up all those emails from the State Department systems. And of course, secondly, she deleted half of the emails she improperly alienated, that's the language of the law, or stole from the State Department. So 33,000 were deleted. Now, Judicial Watch has uncovered through our investigations that the FBI was only able to recover or otherwise find 5,000 of those 30,000 plus emails. So there are 25,000 at least missing emails as a result of Mrs. Clinton and her lawyers deleting them. So when she's telling Congress to roll into the State Department system, don't you believe it? And that's why we asked the question. And that's why we're going to get an answer, thanks to Judge Sullivan, compelling Mrs. Clinton to provide more information. So isn't it remarkable that it's little old Judicial Watch, who's in court, getting successfully Hillary Clinton to answer questions under oath, basic questions under oath, about what she was doing with her email system, why she created it, who was responsible for its creation.